Criminal Procedure, Rule 122, Appeal, Section 1. Who may appeal? Any party may appeal from a judgment or final order unless the accused will be placed in double jeopardy. Section 2. Where to appeal? The appeal may be taken as follows. A. To the Regional Trial Court in cases decided by the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court. B. To the Court of Appeals or to the Supreme Court in the proper cases provided by law in cases decided by the Regional Trial Court. C. To the Supreme Court in cases decided by the Court of Appeals. Section 3. How appeal taken? A. The appeal to the Regional Trial Court or to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its original jurisdiction shall be by notice of appeal filed with the court with rendered the judgment or final order appealed from, and by serving a copy thereof upon the adverse party. B. The appeal to the Court of Appeals in cases decided by the Regional Trial Court in the exercise of its appellate jurisdiction shall be by the petition for review under Rule 42. C. The appeal in cases where the penalty imposed by the Regional Trial Court is reclusion perpetua or life imprisonment, or where a lesser penalty is imposed, but for offenses committed on the same occasion, or which arose out of the same occurrence that gave rise to the more serious offense for which the penalty of death, reclusion perpetua, or life imprisonment is imposed, shall be by notice of appeal to the CA in accordance with the paragraph A of this rule. D. No notice of appeal is necessary in cases where the Regional Trial Court imposed the death penalty. The CA shall automatically review the judgment as provided in Section 10 of this rule. E. Except as provided in the last paragraph of Section 13, Rule 124, all other appeals to the Supreme Court shall be by petition for review on certiorari under Rule 45. Section 4. Service of Notice of Appeal. If personal service of the copy of the Notice of Appeal cannot be made upon the adverse party or his counsel, service may be done by registered mail or by substituted service pursuant to Section 7 and 8, Rule 13. Section 5. Waiver of Notice. The appellee may waive his right to a notice that an appeal has been taken. The appellate court may, in its discretion, entertain an appeal notwithstanding failure to give such notice if the interest of justice so require. Section 6. When appeal to be taken. An appeal must be taken within 15 days from the promulgation of the judgment or from notice of the final order appealed from. This period for perfecting an appeal shall be suspended from the time of a motion for new trial or reconsideration is filed until notice of the order overruling the motion has been served upon the accused or his counsel, at which time the balance of the period begins to run. Section 7. Transcribing and filing notes of stenographic reporter upon appeal. When notice of appeal is filed by the accused, the trial court shall direct the stenographic reporter to transcribe his notes of the proceeding. When filed by the people of the Philippines, the trial court shall direct the stenographic reporter to transcribe such portion of his notes of the proceedings as the court, upon motion, shall specify in writing. The stenographic reporter shall certify to the correctness of the notes and the transcript thereof, which shall consist of the original and 4 copies, and shall file said original and 4 copies with the clerk without unnecessary delay. If death penalty is imposed, The stenographic reporter shall, within 30 days from promulgation of the sentence, file the clerk the original and 4 copies of the duly certified transcript of his notes of the proceedings. No extension of time for filing of said transcript of stenographic notes shall be granted except by the Supreme Court and only upon justifiable grounds. Section 8. Transmission of papers to appellate court upon appeal. Within 5 days from the filing of the notice of appeal, the clerk of court with whom the notice of appeal is filed must transmit to the clerk of court of the appellate court the complete record of the case together with said notice. The original and 3 copies of the transcript of stenographic notes, together with the records, shall also be transmitted to the clerk of the appellate court without undue delay. The other copy of the transcript shall remain in the lower court. Section 9. Appeal to the regional trial courts. A. Within 5 days from perfection of the appeal, the clerk of court shall transmit the original record to the appropriate regional trial court. B. Upon receipt of the complete record of the case, transcript, and exhibits, the clerk of court of the RTC shall notify the parties of such fact. C. Within 15 days from receipt of said notice, the parties may submit memoranda or brief or may be required by the RTC to do so. After the submission of such memoranda or brief, or upon the expiration of the period to file the same, the RTC shall decide the case on the basis of the entire record of the case and of such memoranda or brief as may have been filed. Section 10. Transmission of records in case of death penalty. In all cases where the death penalty is imposed by the trial court, the records shall be forwarded to the CA for automatic review and judgment within 20 but not earlier than 15 days from promulgation of the judgment and notice of the denial of a motion for new trial or reconsideration. The transcript shall also be forwarded within 10 days after filing thereof by the stenographic reporter. Section 11. Effect of appeal by any of several accused. A. An appeal taken by one or more of several accused shall not affect those who did not appeal, except insofar as the judgment of the appellate court is favorable and applicable to the latter. B. The appeal of the offended party from the civil aspect shall not affect the criminal aspect of the judgment or order appealed from. C. Upon perfection of the appeal, the execution of the judgment or final order appealed from shall be stayed as to the appealing party. Section 12. Withdrawal of appeal. Notwithstanding perfection of the appeal, the RTC, MTC, Municipal Trial Court in Cities, Municipal Trial Court, Metropolitan Trial Court, or Municipal Circuit Trial Court, as the case may be, may allow the appellate to withdraw his appeal before the record has been forwarded by the clerk of court to the proper appellate court as provided in Section 8, in which case the judgment shall become final. The RTC may also, in its discretion, allow the appellant from the judgment of the MTC, or MCTC to withdraw his appeal, provided a motion to that effect is filed before rendition of the judgment in the case on appeal, in which case the judgment of the court of origin shall become final and the case shall be remanded to the latter court for execution of the judgment. Section 13. Appointment of counsel de officio for accused on appeal. It shall be the duty of the clerk of court of the trial court, upon filing of a notice of appeal, to ascertain from the appellant if confined in prison whether he deserves the RTC, the CA, or the Supreme Court to appoint a counsel de officio to defend him and to transmit the record upon a form to be prepared by the clerk of court of the appellate court, a certificate of compliance with this duty and of the response of the appellate to his inquiry. Again, appointment of counsel de officio for the accused on appeal. It shall be the duty of the clerk of court of the trial court upon filing of the notice of appeal to ascertain from the appellant if confined in prison whether he deserves the RTC, CA, or the Supreme Court to appoint a counsel de officio to defend him and to transmit with the record upon a form to be prepared by the clerk of court of the appellate court, a certificate of compliance with this duty and of the response of the appellant to his inquiry.